As part of my video lecture series, today we are going to know about an overview of Indian Evidence Act 1872. The Indian Evidence Act 1872 is one of the important procedural laws in India. It was drafted by Sir James Stephen. The Act comprises of 167 sections in 11 chapters. It was came into force from 1st September 1872. It is extended to the whole India except the state of Jammu and Kashmir. The Act is applicable to both the criminal and civil cases. Sections 24 to 30, which are related to confessions, and section 53 and 54, which are related to character of the accused, and sections 122, which is dealing with the communications between wife and husband, and section 133, which is related to evidence of accomplice. These sections are exclusively applicable to criminal cases, whereas section 23 of Indian Evidence Act, which is related to admission in civil cases when relevant, and section 52 and 55, which are related to character of the parties in civil cases, and section 115 to 117, which are related to estoppel, are exclusively applicable to civil cases. As we know that the Indian Evidence Act 1872 is a lex fori, which means it is the law of the country in which action is brought. Simply, when there is a conflict with regard to the rule of evidence in between the Indian Evidence Act and any evidence act of a foreign nation, then the Indian Evidence Act will prevail over such Foreign Evidence Act. The Indian Evidence Act 1872 is applicable to all judicial proceedings in any court or all the judicial proceedings before any court. It is applicable to all labor courts, industrial tribunals, national tribunal, election tribunal. But the Indian Evidence Act 1872 is not applicable to affidavits, arbitration proceedings, court-martial convened under the Army Act, the disciplinary proceedings which are enumerated under Naval Discipline Act, Indian Navy Disciplinary Act and Air Force Act, and the administrative tribunals, commission of inquiries, departmental inquiries, and income tax tribunals. For all these, the Indian Evidence Act 1872 is not applicable. Friends, let us see the concept of evidence under Indian Evidence Act 1872. The word evidence is derived from a Latin word evidentia, which means to clear. Evidence is a means to arrive at a proof. Section 3 under Interpretation Clause of Indian Evidence Act 1872 defines the word evidence. According to this section, evidence means and includes all statements which the court permits or requires to be made before it by witness in relation to matters of fact under inquiry. Such statements are called oral evidence. All documents including electronic records produced for the inspection of the court, such documents are called documentary evidence. It is not a complete definition, it is an incomplete definition for the word evidence. Simply, it categorizes the types of evidence, but it is not very clearly defining the word evidence. According to this section, the word evidence means and includes oral evidence and documentary evidence. Oral evidence and documentary evidence. The documents are inanimated proofs. There is no life for the document. while the witnesses are animated proofs, they have life. Any oral statement given by a witness in relation to a fact in issue or a relevant fact, when such witness comes before the court and he must be permitted by the court after taking an oath, after he is being examined in chief and after his cross-examination and after re-examination if any, after he is being tested by the judge if necessity arises, and after the questions by the party to the witness if necessity arises in case of hostile witness. If the court comes to a conclusion that there is some fact is existed or there is some fact is not existed, it is said to be evidence under Indian Evidence Act 1872. As I said just now, the word evidence is not very clearly defined under Indian Evidence Act 1872. It is an incomplete definition. Certain things like the opinion of the judge or a magistrate as to the demeanor of witness is also evidence, but it is not clearly defined under Indian Evidence Act. And the local inspection by the court, the findings of the court as to such inspection are also treated as evidence, but it is not defined under Section 3. A judge or a magistrate can question the accused and the answers given by the accused may be used against him, but it is not defined under Section 3 of Indian Evidence Act. Hence, it is an incomplete definition for the word evidence under Interpretation Clause of Indian Evidence Act. We need to understand the concept of best evidence rule enumerated under Indian Evidence Act. We need to remember 5 points in relation to the best evidence rule. Rule 1 is oral evidence must be direct. Rule number 2 is hearsay evidence is no evidence. These two rules are enumerated under Section 60 of Indian Evidence Act. Rule 3 is a document should be proved only with the primary evidence, that is, by producing the original document itself. It is enumerated under Section 64 of Indian Evidence Act. Rule 4 is if the transaction has reduced to the form of document, that is into a written form, then the existence of the document excludes all other evidence of transaction. That means it excludes the oral evidence in relation to such transaction, or any matter is required by law to be reduced to the form of a document, that means into a written form, then no evidence shall be given in proof of terms of such document except the document itself. It is enumerated under Section 91. And the last rule, that is the fifth rule, is when the parties have deliberately and intentionally put their agreement into writing, then no evidence of any oral agreement or a statement shall be admitted. It is enumerated under Section 92 of Indian Evidence Act. As we know, any oral statement in relation to a fact in issue or a relevant fact given by a competent witness before the court or permitted by the court after taking an oath, after his examination in chief, cross-examination and re-examination if any, after he is being tested by the judge, after he is being tested by the party who calls him as a witness, and after he is being tested by certain rules enumerated under Indian Evidence Act, his statement is said to be an evidence. Simply, the conclusion the conclusive decision of the judge as to the existence or non-existence of a particular fact is known as the evidence. Any document produced in the similar way, any document produced before the court, such document must be related to a fact in issue or a relevant fact. It must be produced by a competent witness after taking an oath, after his examination in chief, cross-examination and re-examination, after he is being tested by the judge if necessity arises, after he is being tested by various rules of evidence enumerated under Indian Evidence Act 1872, if the judge comes to a conclusion as to the existence of a particular fact or the non-existence of a particular fact, his decision is known as evidence. This is the practical approach to understand the concept of Indian Evidence Act 1872. It must be understood by every practicing advocate in the same way. The general rule is that the court must admit the relevant evidence and it must reject the irrelevant evidence. Section 167 says that if the court admits the irrelevant evidence or the court rejects the relevant evidence, and such admission of irrelevant evidence or rejection of relevant evidence causes the grave injustice to a party to the proceeding, then such evidence must be kept aside and a new trial has to be commenced in order to prove the existence of a particular fact or to disprove the existence of a particular fact. It is enumerated under the last section of Indian Evidence Act 1872, that is 160. Friends, this chart shows the basic understanding of the Evidence Act. In this chart, part 1 is related to fact in issue, relevant facts and irrelevant facts. I am making a separate video on classification of facts. Hence, friends, first watch that concept as to the fact in issue, relevant facts and irrelevant facts. Section 5 deals with the evidence may be given of facts in issue or relevant facts. Section 6 to 55 are dealing with relevant facts. Section 6 is about relevancy of facts forming part of same transaction. It is also known as doctrine of res gestae. Section 7 says about occasion, cause, effect. Section 8 is dealing with motive, preparation, previous and subsequent conduct. Section 9 is dealing with introductory facts or explanatory facts, identification period. Section 10 is dealing with things said or things done by conspirator. Section 11 is dealing with alibi, that is when facts not otherwise relevant become relevant. Section 12 is about facts tending to enable the court to determine quantum of damages. Section 13 is about custom, that is relevancy of custom. Section 14 is about state of mind, body or bodily feeling. Section 15 is about facts whether accidental or incidental. Section 16 is about course of business. Here these section 6 to 16 are related to facts connected with facts in issue or relevant fact. Section 17 to 31 are related to admissions and confessions. Section 17 defines admission. Section 31 says about admission not conclusive proof. Section 18 says that persons competent to make admissions. Section 19 says about admission of stranger or third party. Section 20 says about a statement by referred parties for information. Section 21 says about self-serving statements. Section 22 says about oral admission to the contents of a document. 22A is about oral admission to the contents of electronic document. Section 23 is about admissions in civil cases. Then section 24, 25, 26, 27 are related to confessions. Section 24 defines confession. Section 25 to 27 are dealing with confession to police officer or irrelevant. Section 28 and 29 are dealing with the exceptions to section 24. Section 30 is about the confession of co-accused. Thus, sections 17 to 31 are dealing with admissions and confessions. Section 32 and 33 are related to statements by persons who cannot be called witness. 32 and 33. The statements of persons who cannot be called as witness include a dead person, who cannot be found, who has become incapable of giving evidence, whose attendance cannot be procured without an amount of delay or expense. And section 32(1) is dealing with dying declarations. Section 33 is dealing with evidence given a witness in the previous judicial proceedings and relevancy of the evidence given by witness in the previous judicial proceedings. Thus, section 34 to 38 are dealing with statements under special circumstances. 34 to 38. Entries in books of account. 34. Entries in public records. 35. Maps, charts and plans. 36. Contents of acts or notifications. 37. How much of a statement is to be proved. 38. Here these 34 sections 34 to 38 are dealing with statements under special circumstances. Then sections 40 to 44 are dealing with judgments in other cases according to section 40. Relevancy of previous judgments. Section 41 deals with judgments given by competent court in relation to probate, matrimonial, admiralty or insolvency jurisdiction. Section 42 deals with orders, decrees other than section 41. Section 43 is dealing with judgments other than section 40 to 42. Section 44 is about fraud or collusion in obtaining judgments or incompetency of court may be proved. Thus, section 45 to 51 are dealing with opinion of third parties. Section 45 deals with opinion of experts. Section 45A, opinion of examiner of electronic evidence. Section 46 is dealing with facts bearing upon opinion of experts. Section 46(7) is about opinions to handwriting. Section 47A is about opinions to digital signatures. 48 is about opinions to right or custom. 49 is about opinions as to usage, tenets, etc. Section 50 is about opinions as to relationship, and section 51 is of grounds of opinion. Then section 52 to 55 of Indian Evidence Act are dealing with character of the parties. Section 55 defines character and character as to damages. Section 52 is dealing with in civil cases character is not relevant. Section 53 deals with in criminal cases previous good character is relevant. According to section 53A, in criminal cases previous sexual experience or character is not relevant. According to section 56, in criminal cases previous bad character is not relevant. I would like to make a separate video on character of the parties and relevancy of facts. Friends, this is about part 1, sections 30, 23, 24, 25, 26, 43, 52, 53A and 54 are dealing with irrelevant facts. Please watch my video on classification of facts for more clarification regarding step 1 of this basic structure chart. The next one is statements by persons who cannot be called as witness. As per the definition of the evidence, any oral statement or document produced by a competent witness, such oral statement or document must be related to a fact in issue or relevant fact. He must be produced before the court. It must be permitted by the court. The witness must take an oath. He must be examined in chief, cross and re-examination. Then his statement may be treated by the court and the court comes to a final conclusion. Then it becomes an evidence. This is the rule. Here, the second important part in this chart is witness. A witness may be a competent witness or not competent witness. The oral statement given by a not competent witness is not admissible in evidence. Let us see who is not competent witness. Sections 121, 122, 123, 124, 125, 126, 127, 128, 129, 130 and 131 are dealing with the persons who are not competent as witness. Section 121 says about privilege of judges and magistrates. They cannot become the competent witness. They are not competent to give evidence before the court. But there is an exception to this rule, that is for section 121. The exception is under the order of superior court, a judge or magistrate may give his evidence. He becomes a competent witness. When the matter is not related to his conduct, then he can give his evidence before any court. These are the two exceptions for this rule. But in all other circumstances, a judge or magistrate cannot become a competent witness. According to section 122, privileged communication between husband and wife is protected. Any information given by the husband to his wife or any information given by the wife to her husband as to commission of an offence by the husband or by the wife cannot be revealed before the court. He cannot be treated as a competent witness according to section 122. I would like to make a separate video on competency of witness. Friends, please watch that video. Section 123 deals with evidence as to affairs of the state. Section 124 deals with official communications within the department. Section 125 deals with information as to commission of an offence. Section 126 to 128 are dealing with the professional communications to advocates, their clerks, servants, interpreters, etc. Section 129 is dealing with the confidential communication with the other legal advisors. Section 130 is dealing with the production of title deeds of a document. Section 131 is related to privilege relating to production of document in possession of other person. Thus, under these circumstances, if that person cannot be treated as a witness at any cost. According to section 118, section 118 says about who may testify. All persons, including child of tender years, the senior citizen having extreme old age, the person with a disease, whether of body or mind, is competent to testify. He can become a witness. He is a competent witness to give his oral statement before a court as to existence or non-existence of a particular fact. That fact must be related to a fact in issue or a relevant fact. The only condition is that the witness should understand the questions put to him by the court and he should give the rational answers to the questions put to him. The only condition is he should understand the questions and he should give the rational answers to those questions. Any person and every person is eligible, is competent to give evidence before the court. Even a small child or a person above the age of 100 years, a person who is suffering with a disease, bodily disease or mind-related disease, is also competent to give evidence. The only condition is he should understand the question and he should give the rational answers to those questions. According to section 119, witness unable to communicate verbally. Even a dumb and deaf person can also give the evidence through the signs and symbols using the assistance of the interpreter. According to section 120, parties to the civil suit and their wives and husbands. In all civil suits, parties to the suit and their wives and husbands shall be the competent witness according to section 120. In all criminal proceedings against any person, the husband and wife shall be competent witness. In civil suits, wife and husband are competent witness. In criminal proceedings against any person, the husband and wife shall be a competent witness according to section 120. As we know that section 121, the judges and magistrates have certain privilege. They cannot be treated as competent witnesses. However, there are two exceptions. Under these two circumstances, a judge or a magistrate can give the evidence. He can be treated as a competent witness when he gives a oral statement before a court under the order of the superior court, or when the matter is not related to his conduct, then he may become a competent witness to give his evidence before any court of law. Section 121 is dealing with privilege of judge. 133. Section 133 is related to an accomplice shall be competent witness against co-accused. A co-accused or an accomplice shall be a competent witness against a co-accused. There is some inconsistency with section 133 with section 114 illustration B of Indian Evidence Act. According to section 114 illustration B, the court may presume that an accomplice is unworthy of credit. Thus, there is an inherent inconsistency between these two sections, section 133 and section 114 illustration B. The apex court has given the clarification as to the inconsistency of these two sections in K. Hashim versus State of Tamil Nadu. In this case, the court held that section 133 prevails over illustration B of section 114. Thus, the competency of witness is discussed under section 118, 119, 120, 121 and 133. Certain statements may be given by certain persons who may not be treated as the witnesses. See section 32 and 33 as to the dying declarations who cannot be produced, whose presence cannot be procured, etc. As we know that witness is someone who either voluntarily or under compulsion provides testimonial evidence either in oral or written of what he or she knows or claims to know. There are different types of witnesses: plaintiff's witness, defendant's witness, prosecution's witness, defense witness, expert witness, eyewitness, hostile witness, child witness, dumb witness, chance witness, stock witness, accomplice witness, interested witness, identification witness, etc. This is about the witness. Section 134 is related to number of witnesses. According to section 134, no particular number of witnesses shall be required for proof of any fact. It says that proof of fact depends upon the quality of witness to speak the fact, but not on the quantity. The credible evidence of a sole witness is sufficient to prove a fact or a fact in issue, to establish the guilt of the accused or to the right and liabilities of the parties in a civil proceeding. Hence, quality of the witness is important, but the quantity is not at all important according to section 134. In AIR 2013, Supreme Court, page number 1204, the apex court of this biggest democracy held that to prove a fact, number of witnesses not be essential, quality of evidence is important. In AIR 2013, Supreme Court 2018, the court held that when there are many eyewitnesses, all such witnesses need not be examined. In AIR 2011, Supreme Court, page number 37, it was held that appreciation of evidence of solitary eyewitness is well discussed in this case. Thus, number is not essential, the quantity is not essential, the quality is the sole essential element for a witness, according to section 134. According to section 139, a person summoned to produce a document does not become a witness. A person summoned to produce a document does not become a witness by mere fact that he produces it and he cannot be cross-examined. If he is not cross-examined, he cannot be called as a witness. Hence, if a summon is given to a particular party to produce the document, he is not called as a witness. If a summon is issued to a particular party, if a summon is served to a particular party to produce a document and to depose on it, then he becomes a witness. This is dealing under section 139 of Indian Evidence Act. Section 132 and 147 are dealing with compulsion on witness to answer. Generally, we may have encountered the question like this: whether a witness can refuse to produce a document, or whether a witness can refuse to give evidence on the ground that it would incriminate him. The answer is always no. A witness shall answer all the questions put to him in any civil or criminal proceedings, and he cannot take any excuse from answering on the ground that the answering such question would expose him to penalty or forfeiture or of any kind of punishment. However, basing on his answers, witness shall not be subjected to any prosecution except for perjury, giving false evidence. In AR 1989, page number 398, the Supreme Court held that whenever a witness is summoned in a criminal case, he is legally bound to answer the questions relevant to the matter, though such questions are likely to criminate him directly or indirectly. Section 147 of Indian Evidence Act is also says about when witness to be compelled to answer. It is very clear in this section that if any such questions related to a matter relevant to the suit or proceedings, the provision of section 132 shall apply thereto. It is also similar that the witness is compelled to answer though it incriminate him. The next one, now we have got the clarity regarding the concept of witness. Next, before the court, the witness must give the oral statement, or he must produce a document, or he may give a statement in the form of writing. Such statement or document or the statement of writing must be related to a fact in issue or a relevant fact. He must be a competent witness. He should make a oral statement or a document. He may produce a document to prove the existence or non-existence of a particular fact that must be permitted by the court. When a witness speaks a oral statement or produces a document that is related to a fact in issue or relevant fact, after examination, if the court comes to a conclusion, it becomes an evidence. Here there are certain rules that he must be produced before the court. The statement given by him must be before the court, but not outside the court. He must give such statement before the court. Such statement must be permitted by the court. This is next part. The next one is on oath. According to Oaths Act 1969, especially section 4, oaths and affirmations shall be made by all witnesses, all interpreters, and all jurors while making a oral statement, while producing a document. It must be produced, it must be produced before the court by a witness. The witness must come before the court. He must be a competent witness. He must take a oath according to the appropriate form mentioned in the Schedule of Oaths Act 1969. The interpreters who interpret the signs and symbols of the dumb witnesses and the witness who is unable to speak, such interpreters have also should take the oath. The jurors, at the time of recording the confessions, they must take the oath. There is an exception to this rule. The general rule is that all witnesses, all interpreters, and all jurors must take the oath and affirmations according to Section 4 of Oaths Act 1969. But there is an exception to this rule. If the witness is a child under 12 years of age, and the court is opinion that the child does not understand the nature of an oath or affirmation, and he does not understand the duty of speaking truth, then under such circumstances, it is not necessary to take oath before making a statement, before giving the evidence before the court, according to Section 4 of Indian Evidence Act. Accused person need not take any oath before the court unless he is examined as a witness. If he is not examined as a witness, no oath is necessary according to Section 4 of Oaths Act 1969. Here the form of oath is enumerated under the Schedule of Oaths Act 1969. Form 1 is the form of oath related to witnesses. All the courts in India should follow this form while making a oath to the witness. Generally, the oath of the witness is this: I do swear in the name of God that what I shall state shall be the truth, the whole truth, and nothing but the truth. According to Form 2, the oath of the jurors is in this way: I do swear in the name of God that I will well and truly try and truly deliverance make between the state and the prisoners at the bar, whom I shall have in charge, and a true verdict give according to the evidence. This is the form of oath for the jurors. Next, Form 3 is dealing with the form of oath for interpreters. Their oath is in this way: I do swear in the name of God that I will well and truly interpret and explain all the questions put to and give it and evidence given by witnesses, and translate correctly and accurately all documents given to me for translation. For affirmations, you can replace the word swear in the name of God with solemnly affirm. This is about the oath. When a competent witness makes any oral statement or produces any document with relation to a fact in issue or a relevant fact before the court, after taking the oath, after examination, if the judge comes to a conclusion as to the existence or non-existence of a particular fact, it is said to be the evidence. It is said to be the evidence. I would like to make a separate video on the examination of witnesses. Friends, for better understanding of the concept, go for examination of witnesses, the another video. Here, he may give the evidence orally or in the form of document. Section 59 and 60 are dealing with the direct and indirect evidence. All facts except the contents of the documents or electronic records may be proved by oral evidence. This is the rule enumerated under Section 59 of Indian Evidence Act. When a party to the suit or proceedings proposing to give evidence, the judge may ask the party as to how and in what manner that evidence is relevant. As per this section, that is section 59, it is the duty of the judge or magistrate to admit only relevant evidence in a suit or proceeding. You can also check section 9 of Registration Act and section 10 of Indian Contract Act, which are dealing with the concept of oral contracts, oral evidence, oral deeds, etc. According to section 9 of Registration Act, section 9 of Registration Act, section 9 of Transfer of Property Act, section 9 of Transfer of Property Act, the transfer of property may be in the form of oral statement if the value of the property is less than 100 rupees. Sale of any immovable property less than 100 rupees may be in the form of, maybe orally transferred. Lease of any immovable property for not for yearly basis. Such lease may be in oral form. Any mortgage in which the mortgage amount is less than 100 rupees, it may be in oral form, need not be in writing. Hence, proof of facts by oral evidence is described under section 59. According to section 60, this is the best evidence rule. This section contains the best evidence rule relating to oral evidence. According to section 60, the oral evidence must be direct. The evidence shall be given by the person who perceived the fact in issue or relevant fact by any one of the 5 senses, any one of his 5 bodily senses. The person who saw, who heard, who smelt, who tasted, who touched a fact in issue or a relevant fact, he is said to be a direct witness, and such evidence is known as direct evidence. The hearsay evidence is no evidence, and this is a second-hand evidence. As such, it is not admissible. But there are certain exceptions to hearsay evidence rule. The exceptions to hearsay evidence rule are res gestae under section 6, admission under section 17 to 23 and 31, confessions, persons who cannot be called as witness, evidence given in previous proceedings, statements in public documents, expert evidence, learned treatise, etc. In AIR 2011, page number 206, the Supreme Court held that the newspaper reports are hearsay evidence. In AIR 2012, page number 3046, the Supreme Court held that an eyewitness's version cannot be discarded by the court merely on the ground that such eyewitness happens to be a relative or a friend of the deceased. Yes, thus, much of the priority has given to the oral evidence, that is the direct evidence. Next, the documentary evidence. Section 3 says that document means any matter expressed or described upon any substance by means of letters, figures, or marks, or by more than one of these means intended to be used or which may be used for the purpose of recording matter. You can also check the illustrations. A writing is a document, the words printed is a document, the words lithographed is a document, the words photographed are documents, the inscription on a metal plate is a document, the inscription on a stone is a document, a caricature is a document. According to section 29 of Indian Penal Code, the word document denotes any matter expressed or described upon any substance by means of letters, figures, or marks, or by more than one of these means intended to be used or which may be used as evidence of that matter is known as document, according to section 29 of Indian Penal Code. Thus, section 3 of Indian Evidence Act and section 29 of Indian Penal Code define the word document. Section 61 to 69 are dealing with the concept of documentary evidence. Here, according to section 3 of Indian Evidence Act, evidence may be of 2 types. Evidence is of 2 types, oral evidence and documentary evidence. The second category is the documentary evidence. Section 61 to 90 are dealing with documentary evidence. Section 61 to 66 are dealing with primary and secondary evidences or primary. Section 67 to 73 are dealing with attested and unattested documents. Section 74 to 78 are dealing with public and private documents. Section 79 to 90 are dealing with presumed to be genuine documents. Along with these, we have categorized the concept of documentary evidence as to how to prove the contents of the documents and how to prove the execution or genuineness of documents and what are the presumptions as to documents. I would like to make a separate video on these three aspects with relation to the documentary evidence. And section 91 to 100 are dealing with not under, it is 91 to 100 are dealing with the exclusion of oral by documentary evidence. Section 135 to 116 are dealing with the examination of witnesses. The witness must be examined without his examination in chief, cross-examination and re-examination. He cannot be treated as a witness and his statement cannot be treated as the evidence according to Indian Evidence Act. Hence, the witness must be examined in chief. He must be cross-examined by the adverse party. If necessity arises, he must be re-examined, and the judge has powers. He is not a showman. The judge has power to put the questions or order production under section 165 of Indian Evidence Act. The judge has a power to decide the admissibility of the witness according to section 136. According to section 136, judge has power to decide as to admissibility of the evidence. When a party to the suit or proceedings proposing to give evidence, the judge may ask the party as to how and in what manner that evidence is relevant. As per this section, it is the duty of the judge or magistrate to admit only relevant evidence in a suit or proceeding. He must admit only the relevant evidence. He must reject the irrelevant evidence according to section 136 of Indian Evidence Act. Thus, the judge has the power to admit the relevant evidence and reject irrelevant evidence according to section 136 of Indian Evidence Act. Judge has a power to forbid indecent and scandalous questions according to section 151. Here, the judge may prohibit indecent and scandalous questions. The judge shall prohibit the insulting and annoying questions which are enumerated under section 152 of Indian Evidence Act. Section 154 is dealing with questions by party to his own witness, that is the concept of hostile witness. After examination of the witness, the judge may come to a particular conclusion. Then it becomes an evidence. Along with this, we need to know about various concepts of Indian Evidence Act, the concept of estoppel, the concept of burden of proof, who has to commence the trial, and the concept of proved, concept of disproved. When the judge comes to a conclusion as to the existence of a right or liability on the basis of the oral or documentary evidence given by a competent witness, and he believes, on the basis of that belief, he comes to a conclusion and he makes a particular final judgment, then it is said to be that existing fact is proved. If a person is convicted on the basis of the evidence produced by the prosecution, it is said to be proved. If a person is acquitted on the basis of the evidence produced by the prosecution, it is said to be disproved of the fact or the accusations made against such accused. Section 56 to 58 are dealing with facts which need not be proved. According to section 56, the fact judicially noticeable need not be proved. Section 58 is about facts admitted need not be proved. according to section 41, 112 and 113 and section 82 of Indian Penal Code, there are certain facts which are treated as conclusive proof. Conclusive proof. Kindly see section 41, section 112, 113 and 82 of Indian Penal Code. According to section 41, the judgments in rem with relation to the judgment given by a competent court in relation to divorce, probate, insolvency. Such order of the court is treated as a conclusive proof. It cannot be rebuttable. It cannot be challenged. It cannot be challenged before any court of law. According to section 112, the birth during marriage is a conclusive proof of legitimacy if a baby is born within 280 days from the dissolution of the marriage. Section 113 is about proof of cessation of territory. Section 82 of IPC deals with doli in capax. Nothing is an offence which is done by a child below the age of 7 years. Thus, these are certain other concepts, refreshing memory and some other concepts. Hence, friends, we need to understand the concepts, these concepts in this way.